I want to welcome everybody to today's hearing on cases of child neglect and abuse at private residential treatment facilities. For a number of years now, I've been deeply concerned about the allegations of child abuse in private residential treatment programs, which are often referred to as boot camps or wilderness programs or behavior modification facilities. These allegations range from neglect to torture, a word I do not use lightly. Today we will hear about neglect and abuse cases where the outcome was the worst one imaginable, the death of a child. We will hear testimony from parents of children who died, and I thank them for joining us today and for having the courage to speak publicly about their ordeals. It is estimated that hundreds of private residential treatment programs operate nationwide. The programs are governed, for the most part, by weak patchwork of state regulations. In many states, these programs operate without regulation, licensing, or accreditation of any kind, despite often exorbitant prices of tuition. Parents often send their children to these programs when they feel they have exhausted their alternatives. Their children may be abusing drugs or alcohol, attempting to run away or physically harm themselves, or otherwise acting out. They send their children to these programs because the promises of staff members will be able to help children straighten out their lives. In far too many cases, however, the very people entrusted with the safety, the health, and the welfare of these children are the ones who violate the trust in some of the more horrific ways imaginable. We're aware of stories where program staff members have forced children to remain in seclusion for days at a time, to remain in so-called stress positions for hours at a time, to undergo extreme physical exertion without sufficient food or water. And today we will hear evidence of even more horrifying stories of the children denied access to bathrooms, forced to defecate on themselves, of children forced to eat dirt or their own vomit, of children paired with older children, their so-called buddies, whose job it essentially is to abuse them. There is only one word for this behavior, and that is inhumane. This nightmare has remained an open secret for years. Sporadic news accounts of specific incidents have built a record that should never have been ignored, but shamefully it was. And the federal government has completely failed to grasp the urgency of this situation. In 2003, I urged then Attorney General John Ashcroft to begin an immediate investigation into reports of child abuse in private residential treatment programs. The Attorney General refused, as did his successor, Alberto Gonzales. I also then wrote Secretary of State Colin Powell asking him to investigate the treatment of children in facilities located overseas, but serving American children and operated by U.S. companies. Secretary Powell's response was insufficient. We will learn today that a number of these programs actually operate on federal land, yet no federal agency, not the Bureau of Land Management nor the Department of Interior, no one has thought to review problems associated with these federal tenants despite repeated incidents of injury or death of a child. No federal agency keeps official data about the number of children enrolled in private residential treatment programs, despite the fact that children are typically transported across state lines, sometimes even by force, in order to be enrolled in the programs. And I believe that that is an outrage. In late 2005, I asked the Government Accountability Office to launch an investigation of private residential treatment programs. The GAO agreed, and I am pleased that the GAO has devoted its significant resources to this important issue. Today, the GAO will present case studies of programs where death has occurred. Next year, GAO expects to release an industry-wide review, thus providing us with a comprehensive look at the industry. In the past, it has been estimated that anywhere from 10,000 to 20,000 children are enrolled in these programs at any one time. I am sure that there are programs staffed by caring, professional, and competent staff members who do help to improve children's lives. Yet there are clearly a number of programs staffed by untrained, unlicensed, poorly paid staff members who simply cannot be entrusted with the child's welfare. As a result, without regulation, the industry as a whole will continue to present unacceptable risks to children it serves. That is why in 2005 I proposed legislation to provide resources to states to help them create licensing standards for private residential treatment programs. The legislation would also boost the oversight of facilities overseas operated by U.S. companies. This hearing, as well as the ongoing work by GAO and by the committee's investigative staff, will help determine if it is the appropriate legislative response or if the situation demands something else. One thing is clear, however, that in light of the findings we will hear today, Congress must act, and it must act swiftly, to ensure that the well-being of children participating in these programs. We can all agree we have no mandate more urgent than keeping children safe. And I'd like to thank all of our witnesses for joining us today. We will look forward to your testimony and working with you to put a stop to these abuses.